Common misunderstandings in workers' compensation insurance. One of the most common misunderstandings I see in workers' comp is the concept of limits. Workers' comp has two parts. One part, or the first part, is workers' compensation, which covers the medical expense for an injury, and if needed, the indemnity, partial wages while out of work. Part 1 has no stated limits. Part 2 is employer's liability, which is separate coverage for the owners of the company. Part 2 has standard or statutory limits of $100,000 for each accident, $500,000 for the policy limit, and $100,000 for disease for each employee. Or you can elect to increase the limits in Part 2 to either $500,000 across the board or $1 million across the board. So when talking about limits with workers' comp, remember the stated limits only applies to Part 2, employer's liability. Part 1 has no limits. Now, employer's liability insurance usually covers all types of employer's liability claims unless the policy specifically excludes them. However, some claims are more common than others. Employer's liability lawsuits typically involve one or more of the following four claims. Number 1, third-party overactions. Another party that was held liable for your employee's injury files this kind of lawsuit against your business. So let's say, for example, you own a small construction business. One of your employees was injured using a piece of machinery that you had not properly maintained. The employee sues the manufacturer of the equipment, and the manufacturer turns around and sues you for contributory negligence. Note, in these cases, the employee can still collect workers' comp benefits and file a lawsuit against the third party. Number 2, loss of consortium. An injured employee's spouse files this type of lawsuit. They sue your business because their spouse is no longer able to engage in marital relations after their work injury. Number 3, bill capacity suits. An employee can file this type of lawsuit against their employer when a product the employer manufactures is the cause of their injury. That means you would be liable as both an employer and as a manufacturer. And number 4, consequential bodily injury. If your employee's family member suffers bodily injuries as a consequence of the employee's injury, they could sue your business. An example, say your roofer's wife suffered an aneurysm from high blood pressure or stress after he fell off a roof and became paralyzed. She could sue you for medical damages. So when these claims happen, employer's liability insurance can cover your business's legal defense fees, settlements, damages or judgments, and other court costs. Keep in mind, you don't pay extra for employer's liability coverage unless increased limits is selected. Any questions? Give us a call. Maybe we can help.